If you have an adult child or family member with disabilities or special needs, one of the things you should consider is whether they have signed powers of attorney of property and personal care so that you can assist them with these matters. Now, it may well be that the child is capable because it's not simply a hard, strict test of capacity. It's fact-specific. A person is considered to be competent until proven otherwise. So if it's possible at all, they should sign powers of attorney so that you can actually, as an adult, assist them with their own affairs. Otherwise, what will happen, of course, is that doctors and others will say, oh no, we can't talk to you because of the privacy legislation, which is true. Now, if the child is not capable, then on the far end of the spectrum, then what you're looking at is legal guardianship, which is an application to the court for guardianship of person and property. But of course, there's usually two capacity assessments. There's fees for that. There's some minor court and public guardian filing fees. There's legal fees. So you may or may not decide that this is the route you want to take. But what we find is that quite often the issue is whether the child will be properly treated medically, and if they are, whether the doctors and hospitals will speak to you, the parent, or the brother and sister, which typically, if there's a question as to competence, then the doctors and hospitals err on the side of privacy because they have to, and they won't tell you anything. Now, as a child, you may find that they cooperate, but as an adult, that all changes. Now, it is possible to have a halfway house, and that is that under the Substitute Decisions Act, there's a tree, a hierarchy of who is, in fact, the substitute decision maker for an incapable family member. And initially, it's the parents, but of course, it's difficult often to say to a doctor or a hospital, oh, well, I'm the parent, I'm the substitute decision maker. So what we do is we prepare a substitute decision maker package, which involves affidavits from you, copies of the act, a legal opinion letter, certain other material, and this can then be presented and left on file with doctors and hospitals because you are, under these circumstances, the substitute decision maker. It just needs to be acknowledged so that you have cooperation and more peace of mind.